Letter C. Capital expenditure is a business law term referring to money spent by an organization to acquire new business assets or to maintain or improve existing business assets. Capitalization is a mergers and acquisition term, referring to the distribution of the cost of an asset over the useful life of the asset in the company ledger. Example: instead of putting the entire expenditure for a $15,000 business truck in one period of the accounting balance sheet, a company might spread the cost over the useful life of the truck. Let's say it's useful for 5 years. Then the cost gets spread out over 5 years. Carrier is a general law term which most often refers to an organization which engages in the transportation of people or goods for a fee or some type of compensation. Example: please contact the carrier to make sure the shipment is arriving on time. Carrier is also used to refer to insurance companies or those who carry the risks of a policy for an individual or business. Example: we need to contact our insurance carrier about the accident last week. Cash consideration is a contracts term referring to actual money being used in a contract or in a transaction for an asset, rather than some other type of consideration. Example: we will accept $1 million cash consideration for our firm, plus retention of 10% of common stock. Casualty loss is a contracts term which refers to a sudden loss to a business which is caused by an unordinary event, usually not expected to occur. A good example of this would be a natural disaster which destroys a business's factory. Contrast casualty loss with the gradual deterioration of the factory, which would not be considered sudden or unusual and therefore is not casualty loss. Casualty loss is often used for tax purposes or for excuse from contract performance. Cease and desist order is a general law term referring to a document which is sent to an organization in order to have them discontinue allegedly illegal practices. The document usually serves as a warning that if the recipient does not stop the activity, they may be sued, and judicial enforcement of the order may take effect. Chattel mortgage is a contracts and property term where one borrows capital to purchase movable assets, in other words, not real property, and the lender secures the loan with a mortgage over the chattel. Depending on the laws of the jurisdiction, this means the borrower is the sole owner of the chattel, but the mortgage will not be removed until it is fully paid off. Class action is a general law term referring to a suit brought by a large number of plaintiffs, usually 40 or more but not always, which is intended to protect the due process rights of plaintiffs and defendants from undue burdens in the legal system. For more information including FRCP Rule 23, you can check out Content Binger's Class Action series, which teaches it in 15 minutes. Clean hands doctrine is a contracts term also referred to as the unclean hands doctrine or a dirty hands doctrine, which courts use in equity to prevent plaintiffs from recovery if the plaintiff acted in bad faith or unethically regarding the case matter at hand. Note, the burden of proof falls onto the defendant to prove absence of good faith on the part of the plaintiff. Close corporation is a business law and corporations term and is a corporation that generally has a limited number of shareholders and is not publicly traded. This leads to more flexibility, less requirements, and more exemptions, but also leads to increased risk due to the lack of liquidity for the shareholders and company. Co-partner is a business association's term which refers to the legal relationship of partners in a business. To avoid confusion, you can just think of as synonymous with partners. The general definition of partnership is two or more people agree to go into business together, usually for profit, and the resulting relationship from that agreement will be some type of partnership, the three most common types being general partnership, GP, limited partnership, LP, and limited liability partnership, LLP. Collusive action is a general law and constitutional law term which refers to two parties who bring an action to get judgment, when there is no true controversy between the parties. The parties are often actually working together just to get a ruling from the court, which, if you are familiar constitutional law and the federal rules of civil procedure, you'll know this type of action is not allowed and a court will dismiss the case without a ruling. It breaks case and controversy, adverse parties, and the standing doctrine generally. Commercial frustration is a business law and contracts term for the occurrence of an event outside the control of any party to the litigation, which prevents one or more parties from completing performance under the contract. Commercial frustration is a known defense which is very similar to an impracticability defense and will serve as an excuse for non-performance or perceptual breach of the contract. Commingling is a business law and partnerships and corporations term which in law almost always refers to a fiduciary's obligation to keep their clients' funds and the fiduciary's personal funds. This is mixing or commingling the money. There is often a strong presumption of impropriety in commingling of business assets or client funds, and it is often brought up in corporate law to describe alter ego and shell corporation disputes. The court resolves commingling fiduciary breaches by presuming all profits go to the clients/shareholders and all losses are incurred by the breaching fiduciary. Condition contracts, breach of a condition, is a provision making the effect of a legal instrument contingent on the occurrence of an uncertain future event. Example often comes up in property law: I will grant you my home on the conditions that you graduate college within 5 years, and you never let my low-life cousin enter the premises. Condition can also mean the occurrence of the event itself. Condition precedent is a contracts and property law term that describes a condition that must occur before performance of a contract is mandatory and before rights and interests vest. In the examples given for condition, I will grant you my home if you graduate college in 5 years, is the condition precedent. To avoid confusion, you can just call condition precedent a condition, but you must still differentiate from a condition subsequent. Condition subsequent is a contracts and property term which describes a condition a party must meet or continue to meet to uphold their end of the bargain. In the examples given for condition, this would be: I will grant you my house if you never let my low-life cousin enter the premises. If the grantee, person who received the house, breaches the condition by letting the cousin on the property, there may be a right of re-entry or reversion to the grantor, person who initially granted the property. Condition subsequent, in particular, is often used in contracting business arrangements. Example: I will mow every lawn in your community for 5 years on the condition that the number of lawns to mow does not increase by more than 10% per year. If the number of lawns to mow increases by over 10%, the landscapers will not have a duty to mow those lawns. For the current rate and in some situations, they may be excused from the contract.